Y'all already know how the fuck it's finna go down. I done did my due diligence. I found the motherfucking paperwork. It's your boy Spade Rip. I'm in the building like foster children, man. Put some respect on my mustache, man. Salute me. Straight up. Let's get this shit going. Let's get this shit going, y'all. SpadeRipper.com. Can't spell Spade without the pay in the middle. Yeah, I'm back in the building, man. I done found the paperwork for this Chlöe Bailey lawsuit shit, y'all. We finna comb through the paperwork. I'm gonna pull it up on the screen. Shout out to everybody in the building early. Oh, shit, I see my dog Donnie in this motherfucker. Donnie say walk it down, then we got the motherfucking walk it down. You hear me? When Donnie say walk it down, then you know it's time to walk some shit down up in this motherfucker. Let me hit the emoji, man. Y'all gotta get a membership to the channel to get access to the emojis. You heard? That's how we rocking over here. SpadeRipper.com. You hear me? Yeah. Oh, yeah, Donnie, I'm here, man. I'm here, man. I know it's been a couple days and shit, man, but I've been getting shit together in the background. You know what I'm saying? The channel going up. The channel going up, man. The channel is going up. Let's be clear. I'm making moves in the background, Donnie. I'm trying to get us in the studio, man. I'm trying to get us a straight office set up. You hear me? I'm trying to get us one of them setups like goddamn me, Cameron and Mason, them niggas got. You hear me? I'm working over here. I'm telling you, I'm working over here. I'm trying to find us a building, man. We gonna go up with this shit. We not playing with these niggas when it come to this shit, man. They don't break this shit down how I break this shit down. Shout out to Donnie Wiz. He the only member in the motherfucking building right now. Let me give you your applause, gang. Let me make sure I give you your applause, man, for being the only member that's in the stream right now. You always get here early. I appreciate that, man. If y'all want to get access to the channel, y'all know how to do that, man. Y'all got to get that membership. It's only going to cost you about a hot $3 or something to get access to the emojis and the video. God damn, only a hot $3, y'all. God damn. I know y'all see a nigga Cash App up in the top left-hand corner. Feel free, you can, man, if ain't nothing but $1, man, you can send your boy Cash App. We appreciate support on this channel. You can hit that super chat, too. Yeah, and that's how we rocking. But, yo, check this shit out, man. I had to do my homework on this lawsuit, man, because my people just hit me up. He's like, man, you ain't heard about the lawsuit shit. Because, you know, I got homeboys that be you know what I'm saying? They be hitting me up because they know I be on the hip hop news and the rap news, the music news, and all that shit. You know what I'm saying? I was wrestling with covering this topic because I'm like, well, it's Chlöe Bailey hip hop. You know what I'm saying? And after I got through wrestling with the fact of whether I was trying to find a way to categorize Chlöe Bailey as hip hop so I could feel comfortable covering this shit. Then I had to turn around and do the knowledge on who it is that's actually suing her. And that's a ghostwriting nigga by the name of Forrest. And you know what I'm saying? I want to put some respect on Forrest mustache respectfully because he not necessarily no peon out here. So let me give that nigga some applause just because his name coming up. So, you know, Forrest is a writer, but he's definitely hip hop influenced. And you know how R&B and hip hop finds that particular lane where, you know, it starts to blend together, you know, a la Chris Brown and niggas like that. You know what I'm saying? Don't let it go over your head. Come to find out, this Forrest nigga is a nigga who write for Chris Brown and other motherfuckers, you know, on the hip hop scene, man. So, man, let me read this shit to you. Lawsuit involving Chlöe Bailey and songwriter producer Melvin Forrest Moore. Moore has filed a lawsuit against Bailey and Columbia Records and Parkwood Entertainment, alleging that they failed to appropriately credit or compensate him for his contributions to 3 tracks on Bailey's 2024 album Trouble in Paradise, which in the name of the records are Favorite, Might as Well, and Same Lingerie. In his complaint, Moore claims that the lyrics and narratives of these songs were derived from his personal experience and emotions. He accuses Bailey and her label of exploiting his work without obtaining proper consent or engaging in good faith negotiations regarding payment and credits. Notably, while Moore is credited as a songwriter on Same Lingerie and Might as Well, his name does not appear on Favorite. Moore seeking a court order to halt further commercial use of the songs and investigation to the revenue generated for now unauthorized use and a public retraction of claims made by the defendants. Financially, he is requesting repayment of all profits from the song, monetary damages up to 150 bands for each intentional violation, 150 bands per violation, and $5 million in punitive damage. So the 4S nigga ain't playing with Chlöe. He say, man, where my motherfucking bread at, y'all? I ain't got no time to play with y'all. Where my motherfucking bread? You know, 4S, like I said, he wrote for Chris Brown before Drake, French Montana. He wrote for Nicki Minaj. He wrote Party featuring Usher and Gucci Mane for Chris Brown. And that's a real record right there. Let me give him some applause. Put some respect on his mustache. That's a motherfucking real record right there. He done wrote for Drake. He wrote for French Montana, Nicki Minaj, Ty Dolla $ign. This nigga wrote for John Legend, y'all. He has writing credits on 4 songs from John Legend's 2022 album, Legend. He wrote for Trippie Redd, and he wrote for Jaleel. So he have wrote on some hip-hop songs or some rap songs. He have wrote some hip-hop records, man. I put some respect on his mustache, you know. I'm a ghostwriter myself. If you ain't heard of Spade Ripper before, that might be why. You understand what I'm saying? Because I do got music out myself. But you know what I'm saying? Shout out to all the niggas that's in the background holding this game together. You heard? Shout out to all of us, man, who you know what I'm saying, add seasoning to the motherfucking shit that's on the grill. You heard what I'm saying? You know, I done wrote all kind of shit coming up out of St. Louis. You know what I'm saying? In the background, y'all might not know about. You know what I'm saying? I wrote for that. I wrote for Jibs, man. You remember the little kid rapper Jibs came out? Yeah. But enough about me. Anyway, shout out to 4S because he coming to get his motherfucking bag for these motherfucking people for playing with his motherfucking work. Let's be clear. I got the paperwork. It's like 50 pages. We gonna read through the motherfucking paperwork, and we gonna read through the motherfucking paperwork together. But I do want to show y'all this right here from Billboard. Hold on, let me make it a little bigger, no Diddy. Pause. All right, we're gonna read it together. We see what Billboard said about it. Yeah, I know when I read, I gotta fire up with it. You know, I gotta smoke. I gotta smoke on some hot pack when we do a read along. So let me get this fired on up. So I could put these bitch ass nigga dead homies in the air while I do my blog and laugh at they bitch ass. Hit that cash app. Somebody send me $1, gang. Y'all be playing. If you want to join the stream, you can hit that goal in the you can hit that goal in the chat. I got a super chat goal. If you want to add on to the topic, you want to get up here, I see you the link. You want to trip out with me. You know what I'm saying? I'll be for that. You just gotta hit that. You just gotta hit that. Y'all know what I mean? Yo, so let's read though. So we can get to the paperwork, because the paperwork like 50 something pages, man. I might have to put I might have to let the AI read it to y'all. I don't know if I'm finna read every page. I might have to cut you feel me? The AI voice might have to read it to y'all. You hear me? But let's see what they saying right here, you know. Fraudulent misrepresentation and more. R&B star Chlöe Bailey performance. Chole has been accused of failing to properly credit and pay a songwriter who worked on her album Trouble Paradise, and of commercially releasing the songs he wrote without consent, according to documents filed in a lawsuit filed by attorney Tyrone Blackburn. Is Tyrone Blackburn black or white? I know that's off topic, but that sounds like a black ass name to me, Tyrone Blackburn. Respectfully. Because I am melanated. I'm just saying. Tyrone Blackburn, songwriter Melvin Forrest Moore alleges that the acts of Bailey, along with her label Parkwood and Columbia, constitute copyright infringement, fraudulent misrepresentation, violations of the Digital Millennium Copyright Act, civil conspiracy, and deceptive business practices. According to the complaint, Bailey failed to appropriately credit or compensate Moore in connection with the songs he worked on for Trouble in Paradise. Favorite, might as well say lingerie. I told y'all that already. Which Moore says was written from his own personal and lived experience. He like, man, hold on, these my songs about my bitches, these my struggles. He's not trying to go for that. It also claims that Moore did not grant consent to the commercial exploitation of the songs he wrote for Bailey, and that he did not get an opportunity to engage in good faith negotiations with Bailey's team around contractual terms, citing the email from Moore's attorney to Bailey on August 8th, 2024. He told her to quit tripping. That's what he told her. I don't know what this is right here, but I'm finna. Records from ASCAP and BMI Songview repertory, which contain official accounts about which writers and publishers worked on a given song, indicate Moore is listed as a writer for St. Andre might as well, but not for favorite. Lawsuit claimed Bailey, Parkwood and Columbia, modern day swindlers. You hear me? And claims that Moore's attorney repeatedly made good faith attempts to amicably resolve the matter of unauthorized commercial exploitation of the works over the course of almost 200 days. After not being able to reach an agreement, Moore's attorney says this is a DMCA takedown notice. He told him take his shit down off the internet, asking for the songs Moore worked on to be removed from the internet. The complaint adds that Moore teams feel that takedown was willfully and blatantly ignored. Of course they ignored you. Moore is asking for monetary damages of $150,000 for each intentional violation. The court ordered to stop further commercial use of the songs, a complete investigation of Bailey and Parkwood revenue. Yeah, he trying to get to the money, y'all. Repayment of all profits gained from the songs, requirement for defendants to publicly retract their claims. Yeah. So he not playing with their ass when it come to that. Like, he really want his paper, y'all. He not playing about his motherfucking paper. That man dead ass serious about his motherfucking paper. I got the lawsuit. I got the lawsuit on deck right here. And man, like I say, this shit 50 something fucking pages, y'all. We got a lot of shit to read. We got to dive into this shit. Like I say, man, let me see if I can I might have to get the motherfucking. Damn, I might have to get the motherfucking. I might have to get the AI to read all this shit. It's a lot of shit to read, y'all. There's a whole lot of reading right here, y'all. Let's see what I can do. I'm trying to get it together, y'all. Bear with me. Matter of fact, we'll pause for station identification, and I'm coming back with the paperwork. Don't go nowhere, y'all. Station identification, we coming back, and we finna start reading this long-ass paperwork, because we got a lot to unpack about this shit, you heard?
You ain't got no hands.
Oh, facts. I come through like a big dog. Facts. My OGs taught me pimp talk. Facts. My op was talking big talk. Facts. Now his forehead got a big hole.
It's a fact you ain't got no hands.
Oh, facts. I come through like a big dog. Facts. My OGs taught me pimp talk. Facts. My op was talking big talk. Facts. Now his forehead got a big hole.
It's a fact you ain't got no.
Bitch, I'ma pull up with killers that get your mind gone. Everybody won't be killers till it's really time to go and get your slide on. Bitch, I'ma pull up with killers that get your mind gone. What you know about catching bodies in the street and then switching up your time zone? Bitch, I'ma pull up with killers that get your mind gone. What you know about catching bodies in the street and then switching up your time zone? Bitch, I'ma pull up with killers that get your mind gone. Everybody won't be killers till it's really time to go and get your slide on. Bitch, I'ma pull up with killers that get your mind gone. What you know about catching bodies in the street and then switching up your time zone? Bitch, I'ma pull up with killers that get your mind gone. What you know about catching bodies in the street and then switching up your time zone?
I got the paperwork, y'all. SpadeRipper.com. You can't spell Spade without the pay in the middle. SpaidRPPER.com. Put some respect on my motherfucking mustache. You hear me? We about to dig into this paperwork, man. I just gotta say for the record, I don't know what's true, what's false. I ain't on nobody's side. You hear me? None of that shit. You know. I just know, goddamn me, that this the paperwork. That, you feel me, coming from the lawsuit. You know, motherfuckers be mad these days when you get to talk about what's going on with their ass. You know what I'm saying? But we gonna say that right now for the motherfucking record. You know, entertainment purposes, fair use, entertainment, all of that type of shit, satire, all that type of shit. So don't get mad at us for covering the topic type shit. That's what motherfuckers be on these days. Let's see, man. Let the AI read some of this. Let me see if I can get the AI read to y'all ass, man. Let me see. How do I do this shit? Let me see what I got.
251472 against Chlöe Bailey, Columbia Records, a division of Sony Music Entertainment Incorporated, Parkwood Entertainment LLC, Sony Music Entertainment Incorporated, ABC Corporation 110, and John and Jane Does 110. Complaint. Jury trial. Plaintiff Melvin, more professionally known as Forrest, by and through his undersigned counsel, brings this complaint against Chlöe Bailey, Columbia Records, a division of Sony Music Entertainment Incorporated, Parkwood Entertainment LLC, Sony Music Entertainment Incorporated, ABC Corporation 110, and John and Jane Does 110, and alleges as follows. Nature of action. 1. This civil action seeks damages, declaratory relief, and injunctive relief for defendants, copyright infringement, fraudulent misrepresentation, violations of the Digital Millennium Copyright Act, DMCA, civil conspiracy,
SpadeRipper.com.
practices. 2. Plaintiff Melvin Moore PK of Forrest, a Grammy-nominated singer, songwriter, producer, and recording artist, contributed substantial original lyrics, melodies, and creative direction to several master recordings entitled Favored, Might As Well, and Same Lingerie, inclusive of the underlying compositions, each a work and collectively the works that were commercially released by defendants and embodied on defendant Chlöe Bailey.
SpadeRipper.com.
In Paradise, the album without his knowledge or consent. 3. Specifically, defendants failed to seek permission from plaintiff to commercially exploit works despite actual knowledge of his substantial contributions to the works. Defendants also failed to engage in good faith negotiations with plaintiff prior to the commercial release of the works concerning the contractual terms plaintiff would be willing to accept to grant. 1. Case 125 CV 0147 2L JL Document 1 filed February 20th,
SpadeRipper.com.
33. Defendants the exclusive right to commercially exploit the works. 4. Additionally, defendant failed to accord plaintiff proper professional writing credit for them. Works are compensating for his significant contributions. 5. As with most creatives, the lyrical contributions to the works by plaintiff were deeply personal and inspired by his lived experiences, making the unauthorized commercial exploitation of the works even more egregious. 6. In particular, the lyrics and narratives were derived from intimate and real-life situations, reflecting his relationships, emotions, and personal struggles. A. Might as well was directly inspired by plaintiff's romantic relationship at the time.
SpadeRipper.com.
Had been cheated on, and he encouraged her to take back her power in the breakup. The plaintiff sought to tell the most compelling story from a woman's perspective, capturing the raw emotions and aftermath of betrayal in the work. Defendant Chlöe Bailey intentionally disregarded the DMCA violation and cease and desist notice issued by plaintiff and promoted the work Might As Well on TikTok to over 95.7 thousand people. 2. Case 125 CV0147 2L JL Document 1 file.
SpadeRipper.com. Can't spell spade without the paid in the middle.
B. Same lingerie was inspired by another profoundly personal relationship between plaintiff and a woman who recorded the original demos for the work. The plaintiff and his partner crafted the lyrics based on her hesitations and emotional struggles. Following a previous relationship, the work reflected her discomfort with intimacy, post-breakup, and how she felt she could not wear the same lingerie she once wore for her ex, illustrating a vulnerable and deeply personal perspective on love and loss. 7. 8. Defendant Chlöe Bailey intentionally disregarding the DMCA violation and cease and desist notice issued by plaintiff and promoting the work Same Lingerie on Instagram to over 260,000 people, despite plaintiff's significant emotional and creative investment in the works. Defendants, including Chlöe Bailey, Parkwood Entertainment LLC, Sony Music Entertainment, and Columbia Records, misappropriated his contributions to the works, falsely registered works under their names, and exploited the works for commercial gain across multiple revenue-generating commercially viewable platforms without authorization. Defendants' knowing and willful misconduct includes A. Unauthorized public performances and distribution of the works. B. Failure to appropriately credit or compensate plaintiff as a songwriter and contributor in connection with the works. C. D. Fraudulent copyright registration of the works filed with the U.S. Copyright Office. Continued exploitation of the works on YouTube, streaming services, social media. 3. Case 125 CV0147 2L JL Document 1 filed February
SpadeRipper.com.
2025.
Can't spell spade without the paid in the middle.
EF and other commercially viewable platforms. Circumvention of copyright protections and suppression of plaintiff's claims. And disregarding DMCA takedown and cease and desist notices and legal demands for removal of the works from the stream of commerce. 9. Plaintiff brings this action according to 17 U.S.C. Section 501, Copyright Infringement, 17 U.S.C. Section 512, DMCA violations, 17 U.S.C. Section 506, fraudulent misrepresentation, and New York General Business Law Section 349, deceptive business practices. 10. Plaintiff seeks A.B. actual and statutory damages, including up to $150,000 for willful infringement. Injunctive relief preventing further commercial exploitation of the works. See a full forensic audit of defendants' revenue streams from the unauthorized commercial exploitation of the works. D. Disgorgement of profits and imposition of a constructive trust overall revenues derived from the works. E. An order requiring defendants to issue a public retraction and proper crediting of plaintiff pertaining to the works. F.G. Punitive damages of $5 million per song, and any other relief deemed just and proper by this court, jurisdiction, and venue. 11. This court has subject matter jurisdiction over this action according to 28 U.S.C. Section 1332. Diversity jurisdiction because plaintiff is a resident of California. Defendants are residents of New York and California, and the amount in controversy exceeds $75,000.
Shout out to Skip Kerr.
Interest and costs. 12. This court also has jurisdiction under 28 U.S.C. Section 1331 Federal Question. Jurisdiction at 17 U.S.C. Section 501. Copyright infringement under the U.S. Copyright Act. 13. The venue is proper in this district under 28 U.S.C. Section 1391b, because defendant Columbia Records is headquartered in New York. A substantial part of the wrongful acts occurred in New York, and defendants conduct business in this district. The parties. 14. Plaintiff Melvin Moore, PK of Far West, is an individual domiciled in Woodland Hills, CA 91,367. He's a Grammy-nominated
Skip Kerr in the building, y'all.
producer and recording artist. 2025, page 5 of 33. Plaintiff Melvin Moore, PK of Far West. 15. Plaintiff Melvin Moore, PK of Far West, is a renowned songwriter and producer who has collaborated with Grammy Award-winning A-list performing artists and contributed to several hit records that have achieved commercial success and critical acclaim, and have undoubtedly positively impacted the culture of music and entertainment. His work spans multiple genres, cementing his reputation as one of the industry's most sought-after songwriters. 16. Plaintiff has written and contributed to hit records for the following Grammy-winning and Dora Gold and platinum-selling artists, including but not limited to G-Eazy, French.
Montana, Whistler, Dula Regione, Chris Brown, Doug Collins, Fat, Ariana Grande, John Legend, Jason Derulo.
Damn, why that motherfucker switch accent?
Anne de Brink 17.
The aforesaid contributions by plaintiff reinforce the egregious nature of defendants' conduct in failing to acknowledge plaintiff's rightful authorship in the war.
Okay, all right, I'm gonna get the next part plans. So y'all see how they opening up, right? Shit getting deep up in this motherfucker. It's getting deep up in this bitch, y'all. That nigga Forrest ain't playing by this motherfucking money. He say, man, this shit, my pimping ain't no motherfucking illusion game. I done wrote for French Montana. I done wrote for G-Eazy. I done wrote for Ariana Grande. This nigga say, nigga, I done wrote for Drake, nigga. My pimping ain't no motherfucking illusion. The shit wouldn't have been hot if I wouldn't have wrote it. And it's about my motherfucking life anyway. Man, shout out to that nigga. That nigga ain't playing by this motherfucking paper. I gotta get part 2 going for us, y'all.
Defendant's unwillingness to compensate plaintiff in accordance with his contributions to the works and the overall music and entertainment industries. 18. Plaintiff's unique storytelling ability, lyrical craftsmanship, and melodic genius have contributed to the success of some of the biggest commercially released works in modern music history, both domestically and internationally.
SpadeRipper.com.
The plaintiff's extensive music catalog showcases his ability to collaborate with global superstars, shaping their sound and elevating their projects to mainstream success. 20. Despite plaintiff's proven track record of success in the music and entertainment industries, defendants have engaged in deliberate efforts to erase, diminish, and suppress plaintiffs' contributions and rightful ownership into the works. 21. The defendant's actions violate the plaintiff's intellectual property rights and affront his legacy as a distinguished songwriter and creative force in the music and entertainment industries. 22. Defendant Chlöe Bailey is an individual domiciled in Sherman Oaks, California, 91403. She is a professional recording artist signed to Columbia Records and the primary beneficiary of the works. 23. Defendant Columbia Records is a division of Sony Music Entertainment with its principal place of business at 25 Madison Avenue, New York 10,010. Defendant Columbia Records commercially distributed the works and financially benefited from their unauthorized commercial exploitation. 24. Defendant Parkwood Entertainment, LLC, is an entertainment company with its principal place of business at 1384 Broadway, New York 10,018. Defendant Parkwood Entertainment, LLC commercially distributed the works and financially benefited from their unauthorized commercial exploitation. 25. Defendant Sony Music Entertainment, Incorporated is the parent company of Columbia Records, with its principal place of business at 25 Madison Avenue, New York, New York 10010. Sony Music Entertainment commercially distributed the works and financially benefited from their unauthorized commercial exploitation. 6. Case 125C.
SpadeRipper.com. Can't spell spade without the pay in the middle. SPAIDRPPER.com.
26. Defendants ABC Corporation 110 are corporations or entities whose identities are current, unknown but who participated in, facilitated, or benefited from the wrongful conduct alleged. Herein, 27. Defendants John Does 110 or other individuals and entities whose identities are current, unknown but who have participated in the wrongful conduct alleged herein. Factual background. Defendant's intentional and fraudulent misrepresentation of authorship. 28. Plaintiff is a professional Grammy-nominated songwriter who contributed substantial original lyrics, melodies, and creative direction to the works featured on defendant Chlöe Bailey's album Trouble in Paradise, specifically. A. Same lingerie. B. Might as well. C. Favorite. 29. Plaintiff collaborated with producers and co-writers engaged by defendant Chlöe Bailey, including Euphoro Evan, PK Bongo by Way, producer Bongo, during the songwriting and recording process in connection with the creation of the works. 30. On August 8th, 2024, plaintiff, through his music and entertainment attorney, Tiffany Morgan, Esquire, Attorney Morgan, contacted defendant Chlöe Bailey's counsel, Jeremy Moore, Esquire. Attorney Moore explicitly informing him that his client, defendant Chlöe Bailey, was not the original author of the works. Plaintiff did not grant consent to the commercial exploitation of the works, and a request that both parties engage in good faith negotiations regarding the contractual terms plaintiff was willing to accept to grant defendants the right to commercially exploit the works. See Exhibit A. Email from Tiffany Morgan to Jeremy Moore, dated August 8th, 2024. 31. Despite this clear notice, on August 9th, 2024, defendants and their legal counsel, like modern day swindlers, proceeded to fraudulently file copyright registration documents claiming exclusive authorship and ownership over the works. C. Exhibit B. Copyright Registration Note SR0001013673. 32. These fraudulent copyright filings include U.S. copyright registration number SR0001013673, which falsely identified Sony Music Entertainment and Parkwood. 7. Case 125CV0147-2L.
SpadeRipper.com. Y'all already know what it is. We're going to get through this shit. We're going to know everything about this shit when it's over.
Exclusive claimants and/or authors of the works, excluding plaintiff, despite a significant authorship contributions. Defendant's unauthorized exploitation of plaintiff's work. 33. Despite plaintiff's significant contributions to the works, Chlöe Bailey, as the recording artist, Columbia Records, and Sony Music Entertainment as the distributors of the works, failed to properly credit, compensate, and/or secure plaintiff's consent via a negotiated and fully executed contractual agreement in connection with defendant's unauthorized.
Make sure y'all hit that motherfucking like button. That's right, Skip. Shout out to Skip.
Through her representatives, actively participated in excluding plaintiff from
Hit the like button. Hit the like button.
commercial release of the works. Attorney Morgan repeatedly made good faith attempts to amicably resolve the matter of defendant's unauthorized commercial exploitation of the works, a period spanning almost 200 days. 36. In the vein of amicable resolution, and despite the unauthorized commercial release of the works, Attorney Morgan engaged with Attorney Moore and informed him of plaintiff's position with respect to the unauthorized commercial release of the works. 37. Shockingly, and without plaintiff's consent, Attorney Moore added producer Bongo and Bongo's counsel, Matisla Zulu, Esquire, Attorney Zulu, to the confidential and attorney-client privileged communications between plaintiff and defendant and instructed plaintiff to sort the matter with producer Bongo and Attorney Zulu. 38. Despite the egregious violation referenced above, with seemingly limited options, Attorney Morgan sought to amicably resolve the matter and pushed forward. Attorney Zulu was advised that plaintiff's contractual terms should be on a so-called most favored nations, MF and basis with producer Bongo, i.e., contractual terms, at least least as favorable as those provided to any other similar contributor in connection with the works, with producer Bongo 8, case 125 CB0147 2LJL.
Shout out to Forrest. He want this motherfucking money. I don't blame him. Pay that man.
Negotiations to resolve the matter amicably and in good faith. Still, defendants ignored plaintiffs' requests and denied the MF in terms with producer Bongo, only tentatively, approving them towards the end of the 200-day window referenced above. Notably, Attorney Moore refused to engage with plaintiff and or Attorney Morgan during almost the entirety of the negotiations. 40. Upon information and belief, one can only surmise that Attorney Moore believed that his client was covered due to defendant's deceptive act of registering plaintiff works with the U.S. Copyright Office less than 24 hours after plaintiff, through counsel, put them on notice of his ownership interest in the works. Defendant's willful copyright infringement, NDMCA violations. 41. Upon discovering the defendant's fraudulent misclassification of their ownership interest in plaintiff's works, on January 6, 2025, plaintiff issued a formal cease and desist DMCA violation notice to the defendants.
He said, y'all better cut that shit out.
Commerce. 42. Defendants, including Chlöe Bailey, willfully and blatantly ignored plaintiff's DMCA takedown requests and continued to commercially exploit the works in direct violation of the U.S. Copyright Act, 17 U.S.C. Section 501 at the following. 43. Attorney Moore, legal counsel for Chlöe Bailey and Columbia Records, audaciously claimed that defendants did not require plaintiff's consent to commercially exploit the works despite plaintiff's significant contributions to the works, demonstrating an intentional and reckless disregard for plaintiff's intellectual property rights. The hubris of Attorney Moore and his disregard for plaintiff's rights.
Oh, yeah.
One of the most egregious aspects of this matter.
Egregious.
Displayed by Attorney Moore, legal counsel for Chlöe Bailey and Columbia Records. During a call line, January 7th, 2025, Attorney Moore audaciously asserted that due to the first use exception, he did not require plaintiff's consent to commercially exploit the plaintiff's copyrighted work.
What?
9. Case 125 CB0.
He told that nigga first use, nigga. He told him he had first dibs on the song he wrote, y'all. That is fucking crazy.
Such a claim is legally dubious and emblematic of the pervasive disregard for creators' rights within the music and entertainment industries. 46. This statement directly contradicts the fundamental principles of copyright law, which afford authors exclusive rights over their works, including the right to control.
Hit that like button, y'all. Goddamn.
Public performance. 47. Attorney Moore's dismissive attitude underscores a larger systemic issue. Major record labels and their legal representatives operating under the assumption that they can appropriate independent creators' works without proper credit, compensation, or legal agreements in place. 48. Attorney Moore's assertion disregards the plaintiff's rightful position as a principal songwriter and contributor to the works and reflects a willful effort to undermine contractual and legal obligations. 49. This brazen stance not only warrants legal scrutiny, but also exemplifies why this case demands immediate judicial intervention. 50. If left unchallenged, such unchecked corporate overreach threatens to set a dangerous precedent, one where major labels and their attorneys can freely exploit independent artists. 10. Case 125C.
SpadeRipper.com. They gotta say that, you know, this the shit. They gotta make the judge ponder.
1025 page 11 of 33. Under the guise of legal technicalities, effectively stripping creators of their hard-earned intellectual property rights.
Phone them grand.
Repeated disregard for plaintiff's good faith pre-litigation efforts. 51. In an effort to resolve this matter amicably and without resorting to litigation, the plaintiff sent multiple formal notices and cease and desist letters to the defendants and their legal counsel. These communications explicitly inform the defendants of the plaintiff's authorship and rights over the disputed works. 52. As previously stated, on August 8, 2024, Attorney Morgan emailed Attorney Moore Instead of engaging in good faith discussions, defendants ignored the request and proceeded with their fraudulent copyright registration. See Exhibit 53. Despite this clear notice, on August 9th, 2024, defendants knowingly filed fraudulent copyright registrations, misrepresenting ownership of plaintiffs' contributions. See Exhibit A54. Additional correspondence from the Plaintiffs' Counsel on January 6th, 2025, issued a DMCA takedown request demanding the removal of the works from the stream of commerce. Defendants blatantly ignored this legal demand and continued profiting from the works. See Exhibit C. Email from Tiffany Morgan to Matisela Zulu, January 6, 2025. 55. Jeremy Moore, Esquire, counsel for Chlöe Bailey and Columbia Records, brazenly dismissed plaintiffs' rights, claiming that defendants did not need plaintiffs' consent to exploit this.
Nasty works.
This reckless and legally baseless claim demonstrates the defendant's deliberate disregard for copyright law and independent artists' rights.
On me, get their ass, bro.
Defendant's actions constitute willful copyright infringement under 17 U.S.C. Section 501 and fraudulent misrepresentation in violation of 17 U.S.C. Section 506 E, which criminalizes knowingly providing false information in a copyright registration application. See Rogers v. Coons, 960F, 2D 301, 307, 2D SEER, 1992. Finding willful infringement where the defendant knowingly used another artist's work without authorization.
You hear me?
Case 125C0147.
Get their ass for rest, man. Girl, you got to stand up for all the independent niggas, man. It sounds like they trying to bully for them, don't it, y'all? Fuck that.
Takedown notice constitutes a violation of the Digital Millennium Copyright Act, DMCA, 17 U.S.C. Section 512C. See Capitol Records, LLC v. Vimeo.
See, these the reference points.
126F, 3D78.
You say, nigga, other people that won like this. Why I can't get my money?
Holding that failure to comply with a proper DMCA takedown request may result in liability. 58. Defendants' bad faith actions and refusal to engage in fair negotiations necessitate judicial intervention to rectify these egregious violations of copyright law and ensure accountability for their unlawful conduct. As for the first cause of action, copyright infringement, 17 U.S.C. Section 501, against all defendants, with primary liability on Chlöe Bailey. 59. Plaintiff incorporates all previous allegations as a fully set forth herein. 60. Upon information and belief, defendants knowingly and willfully copied, reproduced, distributed, and publicly performed plaintiff's original contributions to the work saying, lingerie, might as well, and favorite without plaintiff's authorization. 61. Plaintiff is the rightful co-owner of these works, and defendants have exploited them for commercial gain without plaintiff's consent, or proper credit or compensation to plaintiff, and violation of 17 U.S.C. Section 501. 62. Based on information and belief, the defendants coordinated efforts to remove the plaintiffs' authorship information, register the works as their own intellectual property, and mislead third parties, including distributors and streaming platforms, into believing the plaintiff had no rights to the works.
Nasty work.
The defendant's acts of infringement include, but are not limited to, A. Unauthorized public performances of the works at concerts and media appearances. B. Streaming and digital sales on platforms, including Spotify, Apple Music, Amazon Music, and Tidal. See use of plaintiff's work in music videos monetized via YouTube and other video sharing platforms. D. Use of plaintiff's work in advertising, promotions, and merchandise sales. E. Social media monetization through Twitter, X, Instagram, Facebook, and TikTok, using the disputed works to generate engagement and financial revenue. 64. Under 17 U.S.C. Section 504, plaintiff is entitled to actual damages and disgorgement of defendants. Profits attributable to the infringement are statutory damages of up to $150,000
Per willful.
12. Case
That mean every time you I need 150,000 for every time a motherfucker play with me. You hear me? All right, let me get that volume up, Donnie.
Notifications demonstrates intentional and willful infringement, warranting the maximum statutory penalties. 66. Recent case law further supports the plaintiff's claims. In Warner Chappell Music, Incorporated v. Neely, 2024.
You good now?
2,710,034. U.S. 2024. The U.S. Supreme Court held that infringement may be recovered beyond the standard 3-year limitation when the claim is timely under the discovery rule. This precedent strengthens plaintiff's ability to seek damages for defendants' fraudulent actions over an extended period. 67. Additionally,
Damn, we way down here, my bad.
States v. Jung, 2024 WL 1,364,956, 2D Ser. 2024, the Second Circuit reinforced that fraudulent misrepresentation claims require specific allegations of knowing and intentional deceit. Defendants' fraudulent registration and concealment of plaintiffs' authorship satisfy the standard. 68. Furthermore, in Condé Nast et al. V. Cohere, 2025, major publishers sued AI firm Cohere for misappropriating copyrighted works, demonstrating the court's increasing willingness to penalize knowing and willful misrepresentations in intellectual property cases. Prayer for relief. Wherefore, plaintiff respectfully requests that the court A.B. enter judgment in favor of plaintiff and against defendants on all claims. Declare plaintiff as a rightful co-author of the works in dispute.
He deserved that.
Statutory damages of up to $150,000 per infringement under 17 U.S.C. Section 504C. D. Award compensatory and punitive damages for willful copyright infringement. E. Issue a permanent injunction preventing defendants from further infringing upon plaintiff's intellectual property rights. F.G. Award attorneys' fees and litigation costs under 17 U.S.C. Section 505.
Facts.
Award damages under New York General Business Law Section 349 for deceptive business practices. H. Order full forensic audit of all revenue streams derived from the infringing works, including but not limited to I. YouTube earnings and monetization from video plays and advertising. 2. Streaming platforms such as Spotify, Apple Music, Amazon Music, and Tidal. 3. Social media monetization from Twitter, X, Instagram, Facebook, TikTok, and any other digital platform.
And anywhere else y'all getting money at.
Revenue from live performances and concert promotions where the infringing works are performed. V. Licensing agreements for film, television, commercials, and other digital media. B. Physical sales, vinyl, CDs, and merchandising related to the works. 13. Case 125 CV0147 2L JL.
I hope he win. I can't lie.
20th, 2025, page 14 of 33. 7. Advertising revenue and any indirect monetization of plaintiff's works.
Oh, damn. That was the oh, fuck. How much we got left then? Let me see how much we got left, y'all. We got a good little chunk left. Okay. Let me get it back. Let me get it back popping for us. All right. So we was in 3, 4, 5. So we down here. Page okay. Gotta get it right for us, y'all. SpadeRipper.com. Can't spell spade without the pay in the middle. I tell you this much though, y'all. While this shit coming together, I straight hope the dude win because it clearly sounds like they got him for his shit. He clearly wrote the songs. They not denying that he wrote the records. You know what I mean? It's their fault. If they would have just did the paperwork right in the beginning, they wouldn't even be in this situation with bro. And it ain't his fault that they did not put his name on the credits for a record that he wrote. Y'all 2 out of 3. Y'all must have been rushing. Is that his fault? I don't know. I don't know if we can blame him for that. It ain't his fault they was rushing, is it? Shit. They should have put that man's name on that motherfucking music he wrote. That's just That's just what it is, y'all. SpadeRipper.com. We're going to go ahead and do a station identification when I'm getting this shit right. We're going to come back and get the rest of this motherfucking paperwork right. Y'all already know how we do. Stick around.
You ain't got no haters.
Oh, facts, facts. I come through like a big dog. Facts. My OGs taught me pimp talk. Facts. My op was talking big talk. Facts. Now his forehead got a big hole.
It's a fact you ain't got no haters.
Oh, facts, facts. I come through like a big dog. Facts. My OGs taught me pimp talk. Facts. My op was talking big talk. Facts. Now his forehead got a big hole.
It's a fact you ain't got
Bitch, I'ma pull up with killers that get your mind gone. Everybody won't be killers till it's really time to go and get your slide on. Bitch, I'ma pull up with killers that get your mind gone. What you know about catching bodies in the street and then switching up your time zone? Bitch, I'ma pull up with killers that get your mind gone. What you know about catching bodies in the street and then switching up your time zone? Bitch, I'ma pull up with killers that get your mind gone. Everybody won't be killers till it's really time to go and get your slide on. Bitch, I'ma pull up with killers that get your mind gone. What you know about catching bodies in the street and then switching up your time zone? Bitch, I'ma pull up with killers that get your mind gone. What you know about catching bodies in the street and then switching up your time zone? Bitch, I'ma pull up with killers that get your mind gone. Everybody won't be killers till it's really time to go and get your slide on. Bitch, I'ma pull up with killers that get your mind gone. What you know about catching bodies in the street and then switching up your time zone? Bitch, I'ma pull up with killers that get your mind gone. What you know about catching bodies in the street and then switching up your time zone? Bitch, I'ma pull up with killers that get your mind gone. Everybody won't be killers till it's really time to go and get your slide on. Bitch, I'ma pull up with killers that get your mind gone. What you know about catching bodies in the street and then switching up your time zone? Bitch, I'ma pull up with killers.
Yeah, SpadeRipper.com. You already know I'm up in this bitch. Big facts, Donnie. Big facts. You know you got to hit them with that cold motherfucking fax emoji, Donnie. You know you got to hit them with that fax emoji on that bitch ass. Hit them with that right there. Bam. Facts. Yeah, though. Let me see if I can get this shit back going for us, though. So we can finish the saga of this motherfucking paperwork. It sounds to me like they need to pay that, man. I can't even lie to you.
92. Defendants' continued retention of these financial benefits without
Let me get it right.
is unjust, inequitable, and a direct violation of legal principles governing intellectual property, ownership. Prayer for relief. Wherefore, plaintiff respectfully requests that the court ABC enter judgment in favor of plaintiff and against defendants on all claims. Declare that defendants have been unjustly enriched by the exploitation of the works. Order full disgorgement of all revenues generated from the work, including but not limited to I. Streaming platform earnings. 2. YouTube and social media. 3. Live performance and licensing fees.
My bad.
5. Advertising and sponsorship revenue.
My
8.
bad.
Award compensatory damages to plaintiff for all lost earnings and opportunities caused by defendants' unjust enrichment. Issue a full forensic audit of all defendants' revenue streams related to the works to determine the full extent of financial gains derived from the misappropriated content. 17. Case 125 CV
SpadeRipper.com. We're going to get it right.
JL document 1 filed February 20th, 2025, page 18 of 33. FGH. Award punitive damages to deter future acts of wrongful enrichment and unauthorized exploitation of intellectual property. Award attorneys' fees and litigation costs, and grant any other relief deemed just and proper by the court. As for the fourth cause of action, civil conspiracy, fraud, and copyright infringement against all defendants, with primary liability on Chlöe Bailey. 93. Plaintiff incorporates all previous allegations as a fully set forth herein. 94. Upon information and belief, defendants conspired and coordinated their efforts to deprive plaintiff of his rightful ownership, credit, and financial benefits associated with the works. 95. Defendants devised and executed a deliberate scheme to falsely register the works under their own names to suppress evidence of plaintiff's authorship and obstruct his ability to claim his rightful share in and to the works. 96. Based on information and belief, the defendants engaged in secret communications and behind-the-scenes agreements to exclude the plaintiff from all negotiations related to royalties, credit, and ownership of the works. 97. Based on information and belief, the defendants used fraudulent business practices, including altering or destroying documentation that would have evidenced plaintiff's contributions, misleading third-party distributors, and falsely informing industry partners that plaintiff had no valid claims to the works. 98. Defendants' collective actions amount to a civil conspiracy to commit fraud and willful copyright infringement, violating both 17 U.S.C. Section 501, copyright infringement, and 17 U.S.C. Section 506, a fraudulent misrepresentation in copyright registration.
Hit the like button.
99.
Hit the like button.
A claim for civil conspiracy requires an agreement among two or more parties to commit an unlawful act and an overt act in furtherance of that agreement. See Kashi v. Gratsis 790 F 2D 1050 2D Sear 1986. Defendants' fraudulent filings and financial exploitation of plaintiffs' work constitute such overt acts. 100. Defendants have unlawfully enriched themselves through various revenue streams, including but not limited to A. Streaming services, Spotify, Apple Music, Tidal, Amazon Music, etc. B. YouTube and video monetization. See social media platforms such as Twitter, X, Instagram, Facebook, and TikTok. D. Live performances, licensing, and merchandising. E. Advertising revenues and derivative work distribution. 18. Case 125 CV0147.
Yeah, I see what it is, man. I think he gonna win. He clearly deserves it.
25 page 19 of 33. 101. 102. Defendants' fraudulent actions have caused significant financial harm to plaintiff and directly resulted in reputational damage, lost career opportunities, and deprivation of rights.
Subscribe to the channel.
Courts have consistently held that civil conspiracy claims are actionable in intellectual property cases where multiple parties collude to defraud the rightful owner. See Kashi v. Atsis Gratsis 790 F 2D 1050 2D Sear 1986, holding multiple defendants liable for their role in a fraudulent scheme, and your Chlöe Partners, LPV Stewart and Kissel, LLP, 12 New York, 3D 553, 2009, noting that fraudulent misrepresentation in business dealings supports conspiracy. Claims 103, 104, 105. Recent case law further supports the plaintiff's claims. And Warner Chappell Music, Incorporated, v. Neely, 2024 WL 2,710,034, U.S. 2024. The U.S. Supreme Court held that damages for infringement may be recovered beyond the standard 3-year limitation when the claim is timely under the discovery rule. This precedent strengthens plaintiff's ability to seek damages for defendants' fraudulent actions over an extended period. Additionally, in United States v. Jum, 2024 WL 1,364,956, 2D Sear, 2024, the Second Circuit reinforced that fraudulent misrepresentation claims require specific allegations of knowing and intentional deceit. Defendants' fraudulent registration and concealment of plaintiff's authorship satisfy the standard. Furthermore, in Condé Nast et al. V. Cohere, 2025, major publishers sued AI firm Cohere for misappropriating copyrighted works.
These are they cross references to make sure they win the case.
Knowing and willful misrepresentations in intellectual property cases. Prayer for relief. Wherefore, plaintiff respectfully requests that the court A.B. enter judgment in favor of plaintiff and against defendants on all claims. Declare plaintiff as a rightful co-author of the works. C. Award statutory damages of up to $150,000 per fraudulent act under 17 U.S.C. Section 506E. D. Award compensatory and punitive damages for fraudulent misrepresentation and civil conspiracy. E. Issue a permanent injunction preventing defendants from further infringing upon plaintiff's intellectual property rights. F.G. Award attorneys' fees and litigation costs under 17 U.S.C. Section 505. Award damages under New York General Business Law Section 349 for deceptive business practices. 19.
They coming for the money at every angle.
0147 2L JL document 1 filed February 20,
SpadeRipper.com. Put some respect on my mustache. Subscribe to the channel. Like the motherfucking stream.
Order full forensic audit of all revenue streams derived from the works, including, but not limited to, 2, 3, YouTube earnings and monetization from video plays and advertising. Streaming platforms such as Spotify, Apple Music, Amazon Music, and Tidal. Social media monetization from Twitter, X, Instagram, Facebook, TikTok.
Shout out to everybody who likes the stream.
Platforms where the works are used. 5. Revenue from live performances and concert promotions where the works are performed. V. Licensing agreements for film, television, commercials, and other digital media. V. Physical sales, vinyl, CDs, and merchandising related to the works. 7. Advertising revenue and any indirect monetization of plaintiffs' works, including third-party licensing and partnerships. I. Impose enhanced statutory damages under 17 U.S.C. Section 504, C. 2, for willful infringement. J. Require defendants to disgorge all profits unlawfully derived from plaintiffs' works, and establish a constructive trust over any future earnings related to the disputed works. K. Require defendants to issue a public retraction and proper crediting of plaintiff as rightful co-author and contributor to the disputed works. L. Grant any other relief deemed just and proper by the court. As for the fifth cause of action, 106, 107, 108, 109, 110. Violation of the DMCA, 17 U.S.C. Section 512.
They coming for
Against
everything.
all defendants with primary liability on Chlöe Bailey. Plaintiff incorporates all previous allegations as a fully set forth herein. Upon information and belief, defendants knowingly and intentionally violated the Digital Millennium Copyright Act, U.S.C. Section 512, by failing to comply with legally valid takedown notices issued by plaintiff, and continuing to profit from the unauthorized use of the works. The plaintiff issued a formal DMCA takedown request on January 6, 2025, demanding the removal of the infringing works from commercial distribution. See Exhibit C. Despite this legal notification, defendants willfully ignored the takedown request and continued to commercially exploit the works, making them available on multiple streaming services, social media platforms, and digital distribution networks. Upon information and belief, defendants engaged in active circumvention of technological measures designed to protect plaintiffs' copyrights, including but not limited to a. Re-uploading content that had been removed under DMCA notices. 20. Case 125 CV0147 2L JL Document 1 filed February 20th, 2025, page 21 of 33. 111, 112, 113, 114, 115, 116b. Disabling automated content identification systems to prevent detection of the infringing works. See altering metadata and digital fingerprints to obscure.
Damn, they coming, y'all. They coming for their
17 U.S.C. Section 512 F. Any party that knowingly misrepresents material facts in connection with a DMCA claim is liable for damages, including legal fees. Defendants' continued misrepresentations regarding their ownership of the works constitute actionable violations under the statute. Defendants' refusal to comply with DMCA takedown requests and their deliberate efforts to suppress plaintiffs' rightful copyright claims are indicative of bad faith and willful intent to infringe upon plaintiffs' intellectual property. Courts have consistently held that failure to comply with DMCA takedown requests may result in heightened liability for willful copyright infringement. See Capital Records, LLC v. Vimeo, LLC, 826F, 3D78, 93, 2D SEER, 2016, holding that service providers and individuals may be held liable if they ignore DMCA takedown notices or actively facilitate infringement. Recent case law further supports the plaintiff's claims. In Miss F. v. UMG, Recordings, Incorporated, 2024
They coming from
WL
every
5,928,391 2D SEER. 2024, the Second Circuit reinforced that failure to consider fair use before issuing a takedown notice could constitute misrepresentation under the DMCA, emphasizing the requirement for good faith assessments. Additionally, and Second Circuit rejects record labels' attempt to rewrite the DMCA. 2025, the Second Circuit upheld protections for service providers, but emphasized that ignoring DMCA takedown notices or facilitating infringement can lead to liability under 17 U.S.C. Section 512F. This ruling supports plaintiffs' position that defendants' willful disregard of valid takedown notices is actionable misconduct. Furthermore, in Michael Greco Productions, Incorporated v. Raid Sign, Incorporated, 2024 WL, 1,364,956, 2D SEER. 2024, the Second Circuit reaffirmed the application of the discovery rule in copyright infringement cases, allowing plaintiffs to pursue claims upon discovering the infringement. This reinforces plaintiffs' ability to seek damages for ongoing DMCA violations. 21. Case 125 CV0147.
SpadeRipper.com. We getting through this shit, y'all.
JL document 1.
We gonna know
filed
everything
February
about
20th,
this shit.
2025,
Like the stream.
page 22 of 33. 117. Plaintiff has suffered significant financial harm, reputational damage, and continued
Fucking right he
exploitation of
have.
his intellectual property as a direct result of defendants' blatant and willful DMCA violations. Prayer for relief. Wherefore, plaintiff respectfully requests that the court A.B. enter judgment in favor of plaintiff and against defendants on all claims. Declare plaintiff as a rightful co-author of the works.
Facts.
C. Award statutory damages of up to $25,000 per DMCA violation under 17 U.S.C. Section 512F. D. Award statutory damages of up to $150,000 per infringement under 17 U.S.C. Section 504C. E. Award compensatory and punitive damages for willful copyright infringement and DMCA violations. F. Issue a permanent injunction preventing defendants from further infringing upon plaintiff's intellectual property rights and requiring immediate removal of all infringing content. GH. Award attorneys' fees and litigation costs under 17 U.S.C. Section 505. Order full forensic audit of all revenue streams derived from the works, including, but not limited to, I. YouTube earnings and monetization from video plays and advertising. 2. Streaming platforms, such as Spotify, Apple Music, Amazon Music, and Tidal. 3. Social media monetization from Twitter, X, Instagram, Facebook, TikTok, and any other digital platforms where the works are used. 5. Revenue from live performances and concert promotions where the infringing works are performed. V. Licensing agreements for film, television, commercials, and other digital media. D. Physical sales, vinyl, CDs, and merchandising related
all
to the
that
works.
shit.
7. Advertising revenue and any indirect monetization of plaintiff's works, including third-party licensing and partnerships. I. Impose enhanced statutory damages under 17 U.S.C. Section 504, C. 2, for willful infringement. J. Require defendants to disgorge all profits unlawfully derived from the works and establish a constructive trust over any future earnings related to the works. K. Require defendants to issue a public retraction and proper crediting of plaintiff as a rightful co-author and contributor to the works. L. Grant any other relief deemed just and proper by the court. Jury demand. Plaintiff demands a trial by jury on all issues so triable. 22. Case 125 CV0147.
We getting down through it, y'all.
L.
We getting into page 23.
February 20th, 2025. Page
You can't get it
23
nowhere
of
else.
33.
SpadeRipper.com.
Wherefore, plaintiff respectfully requests that the court 1. Enter judgment in favor of plaintiff. And owner of the works. 3. Award statutory damages of up to $150,000 for infringement under 17 U.S.C. Section 504, C. 4. Award statutory damages of up to $25,000 for DMCA violation under 17 U.S.C. Section 512F. 5. Award compensatory and punitive damages for willful copyright infringement, fraudulent misrepresentation, and civil conspiracy. 6. Issue a permanent injunction enjoining defendants from any further use, distribution, or exploitation of the works. 7. Award attorneys' fees and litigation costs under 17 U.S.C. Section 505. 8. Award damages under New York General Business Law Section 349 for deceptive business practices. 9. Order a full forensic audit of all revenue streams derived from the works, including but not limited to A. YouTube earnings and advertising revenue. B. Streaming royalties from platforms such as Spotify, Apple Music, Amazon Music, and Tidal. C. Social media monetization from Twitter, X, Instagram, Facebook, TikTok, and other platforms. D. Revenue from live performances, concerts, and promotional events featuring disputed works. E. Licensing agreements for film, television, commercials, and digital media. F. Physical sales, vinyl, CDs, and merchandising tied to the disputed works. G. Advertising partnerships, sponsorships, and third-party monetization. 10. Impose enhanced statutory damages under 17 U.S.C. Section 504, C. 2, for willful infringement. 11. Require defendants to disgorge all profits unlawfully obtained from the works and establish a constructive trust for any future earnings related to the disputed works. 12. Require defendants to issue a public retraction and credit plaintiff properly as a co-author of the works. 13. Award any additional equitable relief the court deems just and proper. Dated February 20th, 2025. Brooklyn, New York. S. Tyrone A. Blackburn. Tyrone A. Blackburn, Esquire. 1242 E 80th Street, 3rd floor. Brooklyn, New York 11236. Phone 347-342-7432. Email blackburn@tabletburnlaw.com.
All right, so it's more pages to this shit, but we pretty much got through the essence of this shit, though. Because all this shit right here is gonna be like demand for insurance coverage, plaintiff's first set in interrogative document demands to defendants, interrogatories to defendant Chlöe Bailey, identify all the individuals who contributed to the writing, production, and arrangement of the songs, describe your role in the creation, recording, and promotion of the disputed works, state whether you are aware of plaintiff's contributions to be disputed works before their commercial release. They won't put on the stand. How do you testify? How do you go on the record, Chloe? Describe any communications you have with Columbia, Parkwood Entertainment, or Sony Entertainment regarding plaintiff's authorships or contributions to the disputed works. Identify all revenue sources from the disputed works, including but not limited to streaming, digital downloads, physical sales, licensing, live performance. They say, where the fuck did you get some money off this shit from, Chloe? Let's be clear. You know what I'm saying? That's what they want. You feel me? Providing details and discussing negotiation agreements concerning licensing, publishing, and copyright registration. Explain the basis on which you claim ownership or authorship of the disputed works. Identify all social media or digital market efforts in which you promote the disputed works. State whether you receive any cease and desist letters or DMCA takedown requests regarding the disputed works and how you responded. Describe any involvement you had in the copyright registration process for the disputed works. Identify any attorney, agents, and representatives who advise you on the ownership. Yeah. Explain, look, they got how many questions? What's 50 say 21 questions? Nigga, they got 25 questions they want to ask Chlöe Bailey about this motherfucking song. Let's be quick. You hear me? Describe any discussion you had with attorneys regarding potential legal challenges from plaintiff. Number 20 say, explain why plaintiff was not credited or compensated for his contribution. Why this nigga didn't get paid? State whether you personally approve or rejected any request to credit plaintiff. It's gonna get ugly. Document requests to all defendants. All contracts, agreements, and correspondence between among defendants include but not limited to recording agreements, publishing agreements. They say turn everything in. Every conversation you had with anybody, any contracts you had, anything you plan on standing on, you need to bring evidence of that shit to court. You ain't playing. Yeah, all of this is add-ons. All documents reflecting ownership and control of the defendant's social media accounts. They just make it so they don't leave the stones unturned. Yeah, all the politics, the definitions. They got to get the definitions, yeah. These evidences, these is emails. These is emails and communication with people. This exhibit A, exhibit B, you know what I'm saying? Shit like that. So yeah, we got all that. So shout out to the homie 4S because he got all his emails and evidences in to his lawyer in order for this shit to even get filed. You heard? So he got all his shit in. He like it's y'all move, you know. Hopefully, you know, they give him a speedy trial, though. I want to see the brother win, though. I can't even hold you. Get that man this motherfucking money. Y'all know damn well he wrote the motherfucker song. Allegedly, this entertainment purposes. Hey, I'm not no news reporter, man. I'm just a nigga. You feel me? I'm just talking about this shit, y'all. So hold on, though. Hold on, Chlöe Bailey. Hold on, Chlöe Bailey. Don't get mad at me for showing the paperwork. Y'all be trying to take niggas to court these days. Let's be clear. Hold on. Hold on, Chlöe Bailey. I don't know. Allegedly. Entertainment purpose. I don't know shit about shit. I'm just talking about it. You heard? So don't try to Tasha K me. Goddamn me for talking about this shit. I don't know if it's true or not. The man said he wrote the shit. The man filed his lawsuit. He got his evidences. So, you know what I'm saying? Everybody had a day in court. And, you know, we'll see how it go. Hopefully it go well. It go the way it's supposed to go. You know what I mean? We'll just leave it at that, man. Y'all got to make sure y'all get a membership to the channel. I'm finna switch to the members only stream on y'all ass now, and we gonna really talk crazy. It's SpadeRipper.com. You can't spell Spade without the pay in the middle. Get a membership to the channel. Y'all missing out on how we really kick it and what really go down over here. You got to get in tune with me. Check out my website. Check out some of my music. It's lit. It always go down like this. Members only stream coming up. Get a membership. We might watch a bootleg movie or something. Subscribe subscribe to the channel. Subscribe to the channel. Subscribe to the channel. I need one more subscriber, y'all. Come on, somebody subscribe to the damn channel.